Newly released dashcam video shows what began as a routine traffic stop in Oklahoma City, but it's one that prosecutors say ended with an Oklahoma State trooper raping a woman he had pulled over. Court records allege Trooper Jarquez Evans turned off his body camera and microphone during the stop, ordered the woman to a second location under threat of arrest, and sexually assaulted her. We are going to break down the video and the digital and forensic evidence with a criminal defense attorney right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, we definitely wanted to bring you this story clearly, and one of the reasons that we can do that is because of the support that we get from our sponsor, Morgan & Morgan, America's largest personal injury law firm, a firm with over 1,000 attorneys who have recovered, get this, $25 billion for more than 500,000 clients. Think about that. In the past few months alone, a client in Florida received $12 million when insurance offered just $350,000. Out in Pennsylvania, another client was awarded $26 million. That is 40 times the insurer's offer. Morgan & Morgan, they make it easy to fight for what you deserve. You can even start a claim from your phone. So if you're injured, you can start a claim at forthepeople.com/LC Sidebar. You can click the link below, or you can scan the QR code on screen. We have obtained dashcam video that captures the start of a traffic stop that ended with an Oklahoma State trooper now charged with rape. Now, a fair warning here, before I get any further into this one, I'm just going to tell you right now, this is incredibly disturbing if these allegations are true, okay? So the footage shows then Trooper Jarquez Evans pulling over a woman for an expired tag out in Oklahoma City in January of last year. Now, we've chosen not to identify her, but you see him search her, place her in his patrol car, and search her vehicle. But according to court documents, about 18 minutes in, Evans allegedly turned off his body-worn microphone and camera. And court documents allege he then told the woman to meet him at another location or she would go to jail. And it was there that he allegedly, and he is accused of, sexually assaulting her. Now we're going to break down this newly released video, the disturbing affidavit, how DNA evidence from the trooper's own uniform apparently led to his arrest. You wonder how on earth could this happen if it's true. So I want to walk through the allegations from the very beginning. It is January 26, 2025. A woman is pulled over by Trooper Evans, and the reason is there's an expired tag. So for the first several minutes, it kind of looks pretty standard, pretty procedural. Evans has her step out, empties her pockets onto his car hood, then he has her sit in his cruiser while he searches her SUV, and while in his car, she makes some calls, and we can hear some of what she says.
You ran a light.
Well, I'm on 29 and high.
Why should they get pulled over?
The out-of-date tag.
Oh my God, I'm calling. What car are you in?
The new Suburban.
Oh, you're
I don't think I'm going to jail, but I don't know.
Then the official record stops. Evans, according to a lawsuit that was filed by the victim, switched off his body mic and dashcam audio. According to that lawsuit, Evans allegedly never wrote a ticket. Instead, he is accused of giving her a choice, either meet him at a secondary location or go to jail. And under that alleged threat, she reportedly complies. And at this new location, the suit alleges that Evans got into her car, unzipped his uniform, and sexually assaulted her. And afterward, he simply left. No report was apparently ever filed for that stop. But you know what? It was the woman who reported it. The investigation that followed wasn't just about her word. You had OSBI forensic testing on Evans' uniform pants, and guess what they found? Apparently a semen stain. DNA identified Evans as the main contributor. Investigators also found a text that he allegedly sent his ex-wife the next morning saying he'd, quote, done something bad with a woman he pulled over. So Evans was arrested. He was fired. He was charged with rape and forcible sodomy. The victim also filed a civil lawsuit against him and named the OHP as well, claiming they ignored red flags in his past. So you're basically making a claim that he shouldn't have been hired. This is negligent hiring. This is negligent supervision, right? That's the main allegation. Now, here's the thing. The key dashcam video of the traffic stops beginning, that has been released. This is the footage of those final recorded moments before the audio cuts out and the alleged assault began. So we want to go through it. And right away, we see Evans pull over the Chevrolet Suburban. He exits his vehicle. He approaches the driver's side. He has the woman step out of her vehicle. He immediately begins a pat down, empties her pockets, placing her phone, her keys, other personal items on the hood of his patrol car. And then he guides her to the front passenger seat of his cruiser. He leaves her there, goes back to search her Suburban. Evans is out of frame, seemingly searching the vehicle. And meanwhile, she's in his car. And that is when, according to the lawsuit's timeline, she makes those phone calls. It is from there we see a second trooper arrive and appear to aid in the search of this car. Now, the stop continues, and at one point, she gets out of the car to speak with the officers. And more than 20 minutes into the traffic stop, the second trooper leaves. That's when everything changes, because Evans seemingly continues talking to the woman. And according to the lawsuit that she filed, this is when Evans manually deactivated his body-worn microphone and the in-car camera audio. That is what she's accusing him of. That's an allegation. The video may continue from certain angles, but the official audio record, that ends. In this silent video, we see him seemingly walk her back to her Suburban. He returns to his driver's seat. Both vehicles sit for a moment, and then they drive away in the same direction. The dash cam from Evans' cruiser shows him driving kind of a short distance and then pulling over again. And the video shows his parked cruiser with no other vehicle in frame. There's no audio. So his car sits unmoving for seemingly about 12 minutes. And this, according to the affidavit, is the period when he allegedly met the victim at that secondary location and assaulted her. And then finally, the video appears to show Evans starting his car and driving away. The traffic stop from the system's perspective is over. There is no citation that was ever generated. There was no arrest report that was filed. Okay, so to help us try to understand the implications of this case, I'm joined now by criminal defense attorney John Day. John, thank you so much for taking the time. I want to start with the video itself because we see this traffic stop. By all accounts, it looks procedural, and then the audio cuts off for a specific moment. So from a legal standpoint, if this is true, how significant is that act? A trooper allegedly manually turning off his recorded equipment during an active stop. Let's start there.
Right. Well, thanks for having me. So, the old saying is the video doesn't lie, but in this case, it's the absence of the video that doesn't lie either. Why would a police officer have any reason to do any basically editing in the field? I mean, that certainly raises suspicions right off the bat. It's not supposed to happen. You're not supposed to be selectively recording what you're doing as an officer wearing a body-worn camera. So legally, it certainly raises the idea of consciousness of guilt right from the start.
Yeah, unless there was some sort of safety issue, you can claim there's a malfunction, which I don't believe either is happening here. I will say the lawsuit that we're talking about here, this lawsuit claims this wasn't just an isolated act by Trooper Evans, but a failure of the Oklahoma Highway Patrol system, pointing to past red flags like a prior forced resignation from another department, a negligent weapon discharge in the academy. When you look at that, in your experience, how does that argument of negligent hiring, negligent supervision, how does it work in a case like this? What makes it so powerful?
Right. What makes it powerful is it's global. It says, look, this individual officer had a history and he was brought on to the force, the state police force, the highway patrol, in spite of that history. And it alleges negligent hiring, basically no background check, or whether they did a background check, they didn't care what the results were. So the lawsuit alleges the negligent supervision, negligent training, negligent hiring, and also alleges a conspiracy to essentially bring on an officer with that kind of a history onto the state patrol force.
And look, the full scope of these allegations, they are laid out in this lawsuit, this civil lawsuit that was filed in Oklahoma County District Court on August 26, 2025. So you're 7 months after the traffic stop, so 5 months after Evans was criminally charged. We should note this lawsuit was voluntarily dismissed without prejudice in federal court late last year, which means the plaintiff could potentially refile it. But the important part about it, what we want to get to, is the detailed claims. If we take it as true, it provides quite the narrative, okay? And I want to walk through what alleges happened after that dash cam audio cutoff. So first, it claims that Evans never wrote a ticket or made an arrest. Instead, he allegedly used his authority to move the encounter to a second isolated location. Quote, following the stop, defendant Evans instructed plaintiff to meet him at a secondary location. Plaintiff, under continued threat of arrest, complied. GPS data and surveillance footage confirmed that plaintiff drove to a dimly lit area near Southeast 31st Street and South High Avenue, where Evans later arrived. And now here is the core of the sexual assault allegations, because in the lawsuit's own words, it says, upon entering plaintiff's vehicle at the secondary location, Evans unzipped his uniform pants. When plaintiff expressed concern about being arrested for prostitution, Evans assured her that she would not be and confirmed that his body camera was off. Evans ordered plaintiff to bend over. Plaintiff, under duress and fear of arrest, complied. Evans forcibly removed plaintiff's clothing and engaged in sexual activity without her consent. John, back to you. You read this, you take these allegations as true, and obviously, these are allegations, but you read it, it's quite harrowing. What stands out to you from this narrative? Is it the potential digital evidence? Is it the idea of duress or fear of arrest when we talk about if something was consensual or not? It's pretty remarkable, but from a legal point of view, what stands out to you?
Right. Well, remember, the starting place is this is done under the color of law. Basically, they're saying in the lawsuit that the plaintiff was violated, her rights were violated, and her body was violated by a police officer acting under the color of the authority of the state, of the government. And that's where the civil rights violations, the constitutional violations come in, because this is not just, if there is such a thing, an ordinary sexual assault. This is a sexual assault, according to the plaintiff, accomplished because she was under the authority of a police officer, and she was acting with the fear of things like arrest and charges. And she makes that statement about not being charged with prostitution if she engages in this. The whole thing is based on her fear, not only of a police officer, but of the officer's authority and things he could do and things he wouldn't do if she complied.
And by the way, just to be clear, the lawsuit says that Evans then just left. But to be clear, the investigation didn't rely solely on her account. The affidavit details the forensic evidence in this case. Quote, during the subsequent investigation, the Oklahoma Highway Patrol submitted Evans' uniform pants to the Oklahoma State Bureau of Investigation for forensic testing. OSBI analysts located a semen stain on the interior surface of the garment. DNA analysis conclusively identified Evans as the major contributor, and plaintiff could not be excluded as a contributor to the secondary profile. John, in the totality of this, it looks really bad. From a defense perspective, where do they go with that?
Well, where do you go with that? There's not much room for a defense to the charges. You certainly have to allege that DNA could get on clothing from a variety of ways. And if there was any contact from the initial stop, that could certainly contribute to it. But it's just the evidence is overwhelming and it's damning. And if you're trying to defend the civil lawsuit, your best bet is to try to resolve this thing through a settlement and just close the chapter, because it's so sordid and it's so awful for the young woman involved. To have a police officer, the power of the state compelling you to do something like engage in sexual activity, and then the officer basically trying to hide all the evidence, turning off the camera and so on. It's almost an indefensible case from that perspective.
I guess they'd have to explain it was there for some other reason. Maybe he was, doing something, or maybe there was somebody else that he was involved with. I don't know. I don't want to go down that rabbit hole, but obviously we're talking about it. It's an issue. This is interesting. So there's then what the affidavit calls a statement against interest, and we'll talk about it. But the lawsuit reveals this apparent text message. Quote, investigators recovered additional corroborating evidence from a text message exchange between Evans and his ex-wife sent the morning after the incident. In that message, Evans admitted he had, quote, done something bad, referencing a woman he had pulled over the prior night. So, John, when we say a statement against interest, what do we mean? And B, when we talk about potential evidence in a case, we talk about surveillance footage being key, we talk about forensics, we talk about witness account, the text messages, right? Those are some of the most damning because they do go to sometimes a state of mind, unless you're going to be arguing someone else had your phone and sent something. But a message like that, A, what is statement against interest, and B, how powerful is that message?
Right. Well, statement against interest is as it sounds. It's a statement made by a party that is against their potential defenses, that puts them in a place that is not advantageous to them. And in this case, texting an ex-wife something like, I've done something bad, undercuts any possibility that there's going to be some sort of consensual defense to this, that somehow that this was an act that both parties agreed to be. And it shows consciousness of guilt, essentially, on the part of the sender, on the part of the officer, because you don't say I've done something bad if you feel like you've done something good. So the statement against interest here is so clear, and it helps from the plaintiff's perspective establish that he knew what he was doing, he knew he'd done something wrong, and he is documenting that to his ex-wife.
I got to say something. If these allegations are true, This is a member of law enforcement. They know about evidence. Why would you put something in text messages like that?
Yeah, that's a question. But again, was this the best trained and most experienced and smartest police officer around? No. We know about at least the allegations of his history. We know that he had a very cloudy history, to say the least. And so you do have to wonder, if this officer was thinking about things clearly, he wouldn't have done that. But at the same time, if you're the plaintiff, you're grateful that he is not the smartest police officer on the force and that he's established a paper trail and a digital trail that points to his bad acts.
So finally, the lawsuit makes a much broader claim, and that is that the OHP should never have hired or kept Evans. And it points to what it calls a series of red flags. Quote, prior to his employment, Evans was compelled to resign from the Grenada, Mississippi Police Department under circumstances suggesting misconduct of a potentially criminal nature. During his training at the Oklahoma Highway Patrol Academy, Evans negligently discharged his service firearm into a wall within the training facility. This serious incident should have triggered further psychological evaluation. And yet after the detailed allegations that we just outlined, the lawsuit was voluntarily dismissed without prejudice in federal court in January of this year. Before we even get to that, how relevant is everything in the past, John? How relevant is it to the case? How much of that would actually be introduced? Because couldn't you say, you have to have some sort of connective tissue?
Well, if your claim is that the state was negligent when they hired and retained this police officer, you do go into the past. You say, why were they negligent? What did they know? And when did they know it? And if they didn't know it, should they have known it? And why didn't they? So it goes into the officer's history. It goes into reasons why the officer might have been terminated. It goes into anything that shows that he was not suitable to be on the police department. And so you've got, if you're the plaintiff, you've got to dig into reasons why somebody should have raised a red flag early on and said, this person's not suitable. Look at the history here. And then the lawsuit alleges somebody made a decision. That's okay. Let's bring him on. We're okay with that history. And that's where the negligent hiring comes in. And that's where essentially the allegation of a conspiracy to bring him on to the force, even though they knew about the officer's shady past, according to the lawsuit.
So, John, when they say without prejudice, we know that that means the plaintiff, can refile the case in the future. For now, the civil claims against Evans and the Oklahoma Highway Patrol, they're on pause. But this felt like a surprising turn, right? Because from the outside, it looks like a strong case, given the apparent DNA evidence, the text message, the dash cam. Why would a plaintiff and their attorneys choose to voluntarily dismiss a case like this at this stage?
Well, it depends on where you want to be, federal court versus state court. There's some strategic reasons why you might choose one over the other, or there might be discussions going on that nobody knows about. There's a lot that potentially could be happening, but it doesn't seem like the plaintiff is giving up on the claims. It just seems like there's something going on that we may not necessarily know about.
And what are your overall thoughts about the criminal case against him?
It's a strong case. You've got the entirety of a digital trail in terms of the dash camera, the timing. The officers are tracked through their work shift. We know where they were. We've got the video. We've got the video that the officer was self-editing. We've got the statements from the woman and the investigation. So the fact is that if you are someone whose job is to enforce the law, if you choose to break it, that's pretty catastrophic. And there are ways to follow up and track that. So again, the officer, you would think an officer would not even engage in this kind of activity, a sworn law enforcement officer. But like any profession, there are always going to be those who do not live up to their mission.
John Day, great seeing you. Thanks for taking the time.
Thank you.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.